Akita Christina Mayors versus Robert Hollywood.
The record of this matter is before the court to review parenting time. In addition, the plaintiff motion to restrict father's parenting time and defendant's objection to an ex parte order. This hearing is being conducted via Zoom. The president is Attorney John Filkins, representing the plaintiff mother. Ms. Mayors is also present. In addition, Attorney Karen McDonald is present, representing defendant father Robert Pollock. Mr. Pollock is present. The court would note for the record that the court did enter an ex parte order on February 2nd, 2024, which restricted defendant father's parenting time to non-overnights, namely every Saturday from 10 to 6, and prohibiting the presence of father's girlfriend, presence of her during the parenting time. The court would also note that order was consistent with the recommendation of the friend of the court after an interview of the minor child, as well as the child's therapist. In any event, the parties have conferred this morning with the friend of the court. The court has received the following recommendation from Mr. Walker. The recommendation is that the ex parte order continue, that father's parenting time be every Saturday from 10 to 6, and Anna Galanin, the girlfriend, shall not be present. The father and the minor child shall start counseling with a counselor or therapist other than the minor child's current counselor for the purpose of repairing their relationship. The party shall choose a therapist or counselor that is either covered by defendant's insurance, or if not, the defendant shall pay for the costs associated with that counseling. A review hearing shall be held on April 16, 2024 at 8:30 a.m. via Zoom. It's noted that both parties are requesting an evidentiary hearing. That is the recommendation. Ms. McDonald, in your response to pleadings, you suggested you're requesting an evidentiary hearing after the deposition of the therapist, the child's therapist, Mr. DeJulian. Is that what you want to do? Do you want to schedule that
Yes,
deposition?
Your Honor. I've actually reached out to Mr. Julian's office to get some dates that she's available for deposition. I'm going to reach out to Mr. Filkins once she provides those dates, see what his availability is. If I'm not able to get those dates by the end of the week, I'm just going to go ahead and schedule it via subpoena.
Okay. And that seems to make sense, rather than we can secure that to testimony from that therapist rather than clog up the court's docket with an evidentiary hearing from her. And you also suggested that there be a psychological evaluation of the child as well as both parties by Dr. Park. That perhaps there's some merit with that. I don't know, we'll see what Mr. Filkins thinks. And I don't know if he's familiar with Dr. Park. So those two suggestions do seem to make sense. The court is inclined to continue the ex parte order, again, not only based upon the therapist's recommendation, but also the recommendations of Ms. Scott, who interviewed the child. So with that, Mr. Filkins, you asked the court to adopt the recommendation this morning continuing that ex parte order.
With one clarification, Your Honor, I believe that the ex parte order called for visits to be on Sundays, but I thought I heard you say Saturdays.
I'm sorry, I misspoke. Yes, it did say every Sunday, 10 to 6. I just wrote notes on the court's docket, and yes, they did notes every Sunday. That's correct.
Thank you. So yes, to put it simply, my client is in agreement with the recommendations of Mr. Walker. And then I would like to respond to your inquiry with regards to the deposition and the psych evaluation.
Please, because obviously we need to move forward on that on a timely basis. So, Mr. Filkins.
Yes, I would indicate no objection to going forward with the deposition of Michelle DeJulian. I just need to know what date and time is being proposed. With regards to the psychological evaluation, you are correct. I am not familiar with the person that was proposed by defendant's counsel. I'm not aware of what involvement he has with working with minors. At this point, I would suggest that it may be premature, and I would like to suggest that because of the fact we're looking to have the child involved with a counselor or a therapist with father, that we see how that progresses first, rather than adding now a third avenue to this whole thing. So,
Your Honor, just for purposes of clarification, Dr. Douglas Park is a PhD psychologist, not a psychiatrist. I just wanted to make that clarification. And part of the reason that I selected Dr. Park is that he does possess the qualifications for the testing in order to properly test or evaluate the parties in the minor child. He is a known expert in Oakland County Circuit Courts, also a known expert in Macomb County Circuit Courts. I don't know what his experience is in the Wayne County Circuit Court or in Your Honor's court, frankly. I don't know if he's ever appeared there or been appointed. He is an independent and he does possess a PhD psychology. I received his information from Dr. Bowe. And I don't know if the court is familiar with Dr. Bowe, but he has since retired. And in addition to that, Dr. Park's fees, unlike some of the other experts who do this type of work, are substantially less. Some evaluations can reach into $8,000, $10,000, $12,000. Dr. Park's fees are much more modest. And for purposes of my client, it would be more affordable. But certainly, Mr. Filkins should contact Dr. Park, look at his CV, and if there's an alternative, I'm certainly happy to hear it.
Right. So, Ms. McDonald, perhaps you can forward to Mr. Filkins just for his easy review, any information you have regarding Dr. Park, contact information. If you have a copy of the CV, forward that to Mr. Filkins so we can promptly look into that. And if the two of you cannot agree, the court will be inclined to address that when we come back for this review in April.
Thank you, Your Honor.
thank you, Your Honor.
The court does think that should be explored and probably as soon as possible. I mean, before we know it, this child's going to be on her own, and we need to repair that relationship with her father. So at this point in time, the court is inclined to adopt this recommendation of Mr. Walker this morning. I think the evidentiary hearing is a little premature, especially in light of the fact that the counsel wished to depose the child's therapist. If necessary, we can, when we come back in April, the court will schedule an evidentiary hearing at that time. But please discuss the prospects, see if we can agree upon a psychologist that would be mutually acceptable and that's readily available. And perhaps that process can even be started between now and the next court date. Let's move on this matter.
Your Honor, I realize that the court, my client's only objection, I just wanted to place my client's only objection, not trying to dispute the court's ruling at this juncture. I just wanted to address his concern is that he's not allowed, that he shares a house with his live together partner. And so this makes parenting time rather difficult. I understand the court's concern, but if the court were inclined to keep the ex parte order in place, but allow my client parenting time if the live together partner is home, but that my client will make sure or supervise or make sure that his live together partner and the minor child are not alone during that parenting time. Obviously, I see the concern that they don't want inappropriate subjects raised or anything like that. Neither does my client. And I'm putting it out there, Your Honor. I just wanted to express my client's concern about that and see if there were some conditions in the alternative that were less restrictive.
Right, Mr. Filkins, what about that? What if we modified that order that continues the parenting time every Sunday, 10 to 6 for dad, but allows the girlfriend to be present, provided dad is present during all that parenting time? Any objection to that?
Yes, I do, Your Honor. Simply put, after you issued the ex parte order February 2nd, we took the deposition of the girlfriend, and despite your order that there be no contact, she had contact with the child. So my difficulty is I cannot rely on Mr. Palouk to follow the court's order, nor can I rely on his girlfriend to follow the court order.
What type of contact? Phone call or what, Mr. Filkins?
No, he took the child back to his house, and she's at the girlfriend's at the house. And then when the girlfriend, the child's being brought in, the girlfriend and the child either have a short conversation. According to the girlfriend, she hugs the child.
Well, what's wrong with that?
There was to be no contact.
Actually,
right.
that's not what the order says, Your Honor, and I'm not trying to split hairs. It says that she's not to be present during parenting time. They crossed paths in the driveway when Yanni, Mr. Paluk's live together partner, was leaving for the day. They embraced and she left. I don't see how that's harmful contact. And if Mr. Paluk is present, I just think it's a less restrictive condition that accomplishes the goals of the court, the friend of the court, as well as the parties.
Right. And again, Catherine Scott was the one who made the recommendation that the parenting time be with father only. And I'm just reiterating what Catherine Scott's recommendation.
Refresh the court's memory with respect to the letters from Mr. Julian.
Yes.
What was he concerned about the girlfriend?
Primarily, it came down to the girlfriend pulled the child into a domestic argument situation, played recordings, and she acknowledged this in the deposition. She played recording to the child of her father being enraged, involved her in intimate details of the relationship were shared, including allegations of affairs, ongoing betrayal over several months period of time, along with concerns that father does not have his own home or transportation, which was the reason given for them continuing to be together at this time. I would also indicate that during her deposition, she acknowledged that right around this same time, first week of October, she called 911 two separate occasions because of the volatility between her and Mr. Palou. She acknowledged that fact. She called 911. So they may say that they've mended fences, but the difficulty we have is I can't monitor, the court can't monitor what they're going to say or do in the presence of this child. And one way to try to eliminate that is to not have her present during father's parenting time.
And Your Honor, if I may briefly just address that, I understand Mr. Filkins' concerns. However, I would indicate to the court, number one, she appeared for deposition, and when asked a question, she gave an honest answer, which is exactly what she's supposed to do. She acknowledged it. In addition to that, Your Honor, she admitted to playing one recording on one occasion over 12 and a half years of living with this child, and she immediately said, it was a horrible mistake. I should not have done that. I feel and she was even tearful in her response. In addition to that, on two occasions, law enforcement was called. Neither party was asked to leave the house. Neither party was placed under arrest. Neither party was charged with any domestic violence. No children were present. They had a bad argument, Judge. They went through a really rough patch. And it's now become the subject of this litigation. But I would also, Your Honor, indicate that Ms. Galanin indicated in her deposition that she and Mr. Paluk are in a committed relationship, that she's lived with Adriana for over 12 years. She loves her like a daughter, and she feels terrible about it. I'm not saying that she's the focus of parenting time. What I'm trying to indicate, Judge, is that if Mr. Paluk is present, obviously that's not going to occur. In addition to that, she's acknowledged her wrongful conduct, apologized for it, indicated that she would not do it again, and that she is genuinely concerned for Adriana's best interests. I'm just trying to find a least restrictive environment possible.
Mr. Filkins, would you agree that Mr. Pollock and his girlfriend have been involved in a relationship for 12 years, that this minor child has known this girlfriend for the past 12 years, most of her life?
I would agree. But at the same time, the emphasis here is supposed to be on restoring the relationship between father and daughter, not related to maintaining or restoring some sort of relationship between the child and the girlfriend. And the child is the one who brought this issue to the attention of the therapist, Michelle DeJulian, that she didn't want to have contact with her. It wasn't my client's idea, it's the child's idea, and the therapist supports it.
I would just
For this-
indicate, that is disputed.
And
My client has different information, but that's a matter for evidentiary hearing, Your Honor.
And I suggest we're coming back here April 16th. I think that to maintain the status quo at this point is in the child's best interest between now and April 16th.
Very well, Ms. McDonald, your point is well taken, and I would suggest that you address that and raise that again when we come back in April. The court would be inclined to modify the ex parte order, provided father's present at all times. But right now, let's just have dad focus on the relationship with his daughter. So at this time, the court will continue the ex parte order. All the terms of that, it's every Sunday, 10 to 6, and the girlfriend Janice will not be present. Obviously, if in fact she lives in the home, maybe dad goes out to does something outside the home, goes to a museum or a zoo or something with his daughter if he needs to leave the home. So, and then we're just talking about just Sundays. But yes, we can't leave that forever. Obviously, if it's a committed relationship, I mean, maybe Mr. Falk needs to make sure that his girlfriend understands that this is some of her conduct has interfered with this relationship between father and daughter. But in any event, you can raise that, and I want to come back on Ms. McDonald on April 16th. Hopefully, between counsel, some progress can be made toward deposition of the child therapist, securing a therapist that can talk with both the dad and daughter, and also perhaps the counsel can explore the psychological evaluation of the two parties and the minor child. So we can move on that as soon as possible without delay, so we can accomplish something when we come back in April. Anything further this morning, Mr. Filkins or Ms. McDonald?
No, thank
Your
you.
Honor, thank you.
All right, that'll conclude the matter. The court will adopt the recommendation, copy mailed to council. We'll see everyone on April 16th, again via Zoom.
Thank you.
Thank you, Your Honor.
Welcome.
Good morning, Your Honor.
Morning. For the record, this matter is before the court. Excuse me, on the plaintiff's motion to suspend defendant's parenting time. Excuse me. This hearing is being conducted via Zoom. President Attorney Scott Musson, representing the plaintiff Christina Bays. Ms. Bays is present. In addition, defendant Jeffrey Tuval is also present. The parties have conferred with Mr. Pratt this morning from the front of the court. Mr. Pratt has provided the court the following recommendation that the current agreement from September 2023 remain in full force and effect. Mother shall have parenting time every other weekend, and the parties shall exchange a week on, week off in the summer. I believe that Mr. LaPrade drafted an agreement, but yes, it was a consent order entered on September 8th, 2023. The parties agreed to joint legal primary possession to defend father during the school year. Mother shall have the first, second, fourth, and fifth weekends, Friday 4 to Sunday at 7. So the recommendation, it appears, is that continue. All right. So, Mr. Tuval, you're asking the court to adopt this recommendation this morning. Is that correct?
Correct.
All right. Mr. Musson.
We're objecting to it, Your Honor.
Okay. Your petition alleges that the child was inappropriately touched and the child tested positive for marijuana. Father was providing the child with marijuana or smoking in very close proximity to the minor child. What's the status of the CPS investigation?
The CPS investigation, there's two aspects to it. The first aspect was the child talk for the inappropriate conduct that was alleged. The letter that we received prior to the last referee hearing stated that they did an interview with the child and the allegations were not substantiated on that particular issue. The second aspect of it is the CPS has had them enter into basically a case plan for services which include, back one page, complete a domestic batterers course, random drug screens, attend and complete a dual diagnostic assessment. And, as far as the CPS report goes, the reason for it is without intervention of the case plan services, the children would be at risk of entering foster care. It was developed with Mr. Tuvelli, agreed to it. And there's some notable admissions in it. One that it states right here, Jeffrey has a history of substance abuse and admits to using cocaine recently. His statements, he's denying that, but those are his statements to the CPS investigator that he used it recently. He's got issues with domestic violence, having been arrested on December 1st for threatening to kill his wife. I have 2 affidavits that we attached. One was the grandma who coordinates the pickup and drop off, who witnessed him punch a roll top desk and punch a 55-inch TV. We have the sister, Ashley Bays, who talked about the marijuana. To be open and frank with the court, we don't have the medical reports. I don't have those, Your Honor. The other problem we have is with all that's going on, the child is in school. Mr. Tuvel just admitted that she has been suspended 3 times from school, which is kind of a lot for a child of her age. And when you've got domestic violence going on in a home like this, and it's affecting the child in that manner, I think it's probably a little more prevalent than what we see in some of these reports. But there's definitely a problem here. And our request to the court is simply give mom primary custody, supervise dads until he gets a clean bill of health from the CPS investigation and this case plan.
All right, thank you, Mr. Musson. Mr. Tubal, first of all, your child's 6 years old. She's been suspended 3 times recently.
Correct. Not recently. No, this was at the beginning of the school year. Literally the first month of the school year. Since then, her teacher I was actually looking for her report card. On her report card, she said she's done a pretty good turnaround, and there's the spitting and stuff like that was at the beginning. I couldn't believe it. Obviously, we got her into counseling, and since then, she's learning at an amazing rate. She's paying attention in class. She said she's a totally different person. I think a lot of was an adjustment to a new school. She did have a problem listening to authority, and I think she's definitely growing up a lot, which made me it makes me so proud to, see her grow like that, and just at the rate that she is learning, and not letting the behavioral problems is no longer an issue that gets in her way of being able to learn.
So these suspensions occurred in September of 2023. Is that what you're saying? The 3 suspensions?
September and then in October.
Okay. Is your daughter currently in counseling?
Yes.
Okay. How often?
She's in counseling at a place called not Unison, but it's I can't think of the name. It's right over here off Cherry Street.
How often?
She goes once a week there, and then she also is in a class that we got her into her school. It's called PGN, and she sees the counselor. She meets with the counselor every day.
Okay, Mr. Musson, is your client aware of the name and identity of these counselors?
No, Your Honor.
All right, Mr. Tuvel, the 2 of you have joint legal custody. It means you need to share equally any major decisions concerning the welfare of your child. So if you put the child in counseling, you need to inform mom who the counselor is, the office location, how often, name of the counselor, and so forth.
Yes, and I do, and I have. Yes, just like when I explained with her report card that and I'm not trying to be blunt about it. Like, she really is just like, oh. I was like,
That's
okay.
not true. You were going to send it to me, and I was leaving with our daughter when I picked her up.
I was trying to show it to you.
Oh, you weren't. You said you were going to send a picture to me on the app close.
Yeah.
All right. Obviously, Ms. Bays, you should be attending parent-teacher conferences. You should be actively involved with their child's education. talking with the teachers. I'm sure they can go online and find the schedule of school activities. When there's parent-teacher conferences, you should be attending
I don't
those.
even have her record. I don't even, they won't let me. I tried calling her school, got records, try to get records for. I don't even have, I'm not on the thing.
Well,
That's
you
not
have
true because you
legal-
are.
Okay.
Yes.
Mr. Tula, she should be listed as emergency
Okay.
contact person.
Yes, she is.
Okay. And
Okay.
Ms. Bays, you should be able to go online. Do you know the name of the school, correct?
Yeah.
You should go online and be able to see all the activities, parent-teacher conferences, and you should be attending those. You talk firsthand with the teacher. So you get
I
firsthand.
even called there and they said they couldn't
release
release that information is because Jeff, I had to get it from him.
Well, you've got an order of September 8th that gives you joint legal custody. Perhaps Mr. Musson can assist you in that regard. All right, the court's inclined to adopt the recommendation of Ms. Pratt this morning. The court's not convinced there's a significant change in circumstances that would warrant suspending dad's parenting time, which would be tantamount to modifying custody. The parties agreed in September, not even 4 months ago, 5 months ago, to joint legal physical to dad during the school year, week on, week off during the summer. So the court believes that schedule should continue unless there is stronger evidence before this court. Is there anything further this morning, Mr. Musson?
No, Your Honor.
All right, the court will adopt this. A copy will be mailed out, and Ms. Bays, Mr. Musson perhaps can assist you in reaching out to the school. You should definitely be attending those parent-teacher conferences. You should know, and you should be in contact with the counselors too, so you have a better insight in terms of what's going on in your daughter's life.
Your Honor. I have no problem assisting her too as well. I know that it does cost money to get a hold of legal representation like that, quite a substantial amount, and I don't want to have to see her do that. And I've told her, we communicate through the app Close, so it's monitored. She's never reached out to me, and I have no problem. Like, I never, ever, ever want to take my daughter's, the mother of my daughters out of their life, because I grew up without a father and I held resentment for a lot of years. So I know how that is. And I am always on board with co-parenting.
Well, you owe that to your daughter, Mr. Tuval.
That's
you owe
exactly
it to your daughter.
Right. Exactly.
And obviously, if evidence comes to before this court that your daughter's been exposed to drug use, you're going to lose possession of your daughter. So you can't have people around that are smoking marijuana in her presence. Absolutely, that's inappropriate.
I do not. I will take it. I'll do a test today. I don't smoke marijuana. I'm a Christian. I believe in the Bible, and I live by the word.
Do not let third parties smoke marijuana in her presence.
I do not. That's another thing. That's invitation to the devil. We don't hang out with people like that.
All right, there's allegations, so just be aware, Mr.
Yes.
Duval. All right, court will adopt the recommendation. Thank you, Mr. Pratt. That will conclude this matter. We can zoom out. Have a good rest of the day.
You as well. God bless.
Your Honor, may I ask a quick question? Is the court going to issue that order as is, or do I need to draft one and submit it?
It's up to you. I think this will cover it. It just indicates that the agreement or order of September 2023 shall remain in full force and effect. Mothers, now this is a little bit different. This says mother shop every other weekend. Now, as the court recall, the September 8th order shall be mother's parent time is the first, second, fourth, and fifth weekend of the month.
Your Honor, I think I grabbed referee Homerch's recommendation. I can retype that as first, second. You said first, second, and fourth.
You just simply reference the court order of September 8th, 2023 shall continue in full force and effect.
Yes, sir, I can do that.
That specifies that mother shall parenting time the first, second, fourth, and fifth weekends of the month, Fridays at 4 to 7, Sundays at 7, and week on, week off during the summer.
Yes, sir, I'll upload that.
Okay. So I think this, with court adopting this recommendation, that should suffice, Mr. Musson.
Okay. Thank you, Your Honor.
You're welcome.
Thanks, Your Honor.
Mr. Tuval, Ms. Bays, keep in contact, communicate with each other regarding the welfare of your daughter. It's real critical.
Yes, it definitely is. Thanks again. God bless you. Have a great day.
Court is now in session, but on page 1, Tyler Zonka versus Kaylee Durmerton.
Record this matter before the court, the purpose of reviewing defendant mother's parenting time at the request of the friend of the court. This hearing is being conducted via Zoom. Present is Attorney Derek Jocks, representing the plaintiff father, Tyler Zonka. Mr. Zonka appears to be present with Mr. Jocks. Is Kaylee DeMerchant present in audio?
I don't know how to fix my camera and stuff. I went to Polycam and I don't know what I did. So
I'm sorry.
out here. Okay.
Oh, there. Okay. Now we can see you. Good morning.
Yeah.
Good morning, Your Honor.
I'm sorry. The last statement you made was garbled. I didn't understand it, ma'am.
Yeah, I couldn't see where the video was. I apologize.
Okay, the parties have conferred with the front of the court this morning. The front of the court has provided the court with a fine recommendation that the ex parte order of June 2023 shall continue. That order suspended mother's parenting time. Further noted that defendant's mother may request a court date to review parenting time by submitting a written request after she is successfully completed inpatient therapy. That is a recommendation. Mr. Merchant, do you understand the recommendation?
I understand the recommendation. It was my recommendation to the court to do that. I did complete inpatient rehab in July. And I also went to treatment. However, I was discharged due to an eating disorder. But I had several write-ups regarding like food and everything like that. Now it ended on somebody yelling at me and I got dismissed. I was 2 days away from completion of that at Sacred Heart in Clearview. I did want one visitation day with my son. My son wants to see me. He doesn't know where I'm at. He doesn't understand. He doesn't want to get off the phone with me when I call him and things of that nature. And it's like, I thought that would be fine, but it's not. If you can't grant that, Judge, the only other request I would have then is instead of me doing a formal written letter about requesting a hearing, this took 3 months for me to get this hearing. And I don't want to complete psych and then that may be at the most 2 weeks that I'm in there, and then the hearing is pushed off another 3 months. I need to see him.
It's hard to understand.
Okay. You're very difficult to understand, ma'am. Obviously, the device you're using is not very clear. Perhaps you should call in. But again, obviously, I understand. First of all, you're going to provide documentation from Sacred Heart and so forth that you've completed therapy. Is that correct?
Well, I mean, I'm going to go up to Grand Rapids to a facility up there. So I'm not sure where I'll be placed or anything like that. But the most my insurance can do is about a 10-day stay. My request to you is, I did want one visitation day. I didn't think that was a lot to ask. Like I said, my son does miss me. But if you can't grant that, then is there a way that you could just schedule the hearing out so that I'm not waiting 3 months for another hearing because I have to do everything in writing and make it formal like that? I would appreciate it if I didn't have to do those steps.
We can do that. We can schedule a date a couple months out with the idea that you're going to provide some reports to the court as well as Mr. Jacques. What are you suggesting? 2 months?
I wanted it much sooner than that. I'm only going to be in treatment for 2 weeks. They said upon completion of the treatment that we could re-intervene and see if there's anything I can do. But I need to see my son.
Yeah, when you come back, maybe get a different device, ma'am. I know sometimes your voice is real strong. One time it's sort of hard to understand exactly what you're saying. So I'm not sure if it's a device, but
I wanted to be a little bit closer than 2 months away, please. Is it all possible?
So let me ask you, have you in fact completed, is there completed inpatient treatment?
Yeah.
Are you currently involved in outpatient?
Yes.
Okay. How often is your outpatient? Every week, every 2 weeks?
I'm in a domestic violence group as of right now. That's out towards Port Huron.
I'm sorry. Can you repeat that?
I'm in a domestic violence group that's outside of Port Huron. There's something wrong.
Okay. But I know the court's more concerned about substance abuse issues. Are you still involved in substance abuse aftercare?
That I will be addressing as far as like AA and any meetings go.
Ma'am, looking to speaking of your advice, you keep turning your head, and I'm missing half what you're saying. So if you,
I don't know how to fix
that's better. Right, just
phone.
don't keep turning your head to the side.
Okay.
That's much stronger.
Okay, I can participate in AA and NA meetings. As of right now, I will be staying with friends that I know Tyler trusts with, as far as like, them helping me out. They are located in Novi, and then I'm currently pregnant right now, and I was gonna continue on after I delivered. I was going to go again, reconvene and do the inpatient and then go back out, into inpatient substance abuse as well. That's what my plan was, so that.
We
'Cause
got
I
half
have
of what
it,
you said, Mr. Merchant. The court's gonna give you a phone number. Why don't you write down this phone number, so next time you appear calling by audio, we can hear you much clearer, okay?
Okay.
You got a piece of paper and a pen?
Yeah.
Do you get that phone number?
Yes, sir.
Okay, then after the phone number, it'll prompt you then to type in the court Zoom ID number. So keep the court Zoom ID number. Okay,
Okay.
and you got that for today. You'll be much clearer and easily understood if you appear by audio rather than the device you're using. Right, the court has a date, March 12th. That Mr. Jacques, are you available either 10 o'clock or 2:30 to review mom's parenting time and her progress? Do you prefer one time over the other?
2:30 would work for me, Your Honor.
Okay. All right, Mr. Walker, good morning. Can you put in there the court review mom's parenting time, March 12th at 2:30? Between now and then, we got a month. Mr. Jacques, Mr. Merchant, what about some supervised parenting time for mom so she can have some contact with Jack? Is Mr. Zonka comfortable with that in terms of bringing Jack over? Maybe they can meet somewhere, McDonald's or something, a playland, have lunch, and the child can see mom.
I think that the issue that Mr. Zonk and myself have with that is we don't have any proof of sobriety at this time, and there's been a lot of other things that have occurred in the background that raise serious concerns with regard to the psychological.
Don't deny my parenting time, please. Just one
Wait,
day.
hold on, ma'am. Please don't interrupt. Mr. Jack's obviously supervised, so obviously if mom's under the influence, then obviously dad would just leave.
I understand that, Your Honor, but we still have concerns about the lack of proof of sobriety, the lack of drug testing, the fact that she was discharged from the previous center prior to completion, and then an incident occurred with a man that she was in a relationship with, which
I'm no longer
trying to obtain a PPO against himself and their son Jack because of threats of death and serious bodily harm against the child by this individual, and the fact that after he was arrested on some fairly serious crimes up in St. Clair County, that Mr. Merchant continued to live with them for approximately another month.
Right, but I'm talking about supervised parenting time. We're not talking about unsupervised, something where dad would be present. Is he comfortable being in the presence of the woman that he chose to be the mother of his child?
I have a concern with the PPO that's in place, and I think that the volatility that has occurred previously between the two parties sets that up to fail at this point in time. I think that any supervised parenting time in the future would have to be done through a center or with a trusted third party, but I don't think that we're at the point that we're ready for that.
Well, obviously, any third party supervising parenting time would discontinue any parenting time if, in fact, mother was under the influence. We just have a 5-year-old child that the court's concerned. Yes, this order goes back to August of 2023. Mother failed to appear for a hearing at that time. The court continued the order of June. It's been 6 months since mom's had any physical contact with this 5-year-old child, and that we need that contact. So the PPO, who sought, so Mr. Zonka sought the PPO against Mr. Merchant, is that correct?
That is correct, Your Honor.
And that prohibits any contact?
It does.
Okay. Mr. Walker, there's still a waiting. Right. Well, I guess we'll address this, Mr. Merchant. So provide as much records information as possible on March 12th. at 2:30. Mr. Walker, you're still a waiting list with Family County Child Services, correct?
Yes, there is, Your Honor.
What's your thought? Should we wait till March 12th to address that? Because I know it's going to be, what, a month or two on the waiting list, or should we get the parties on the waiting list?
Your Honor, it'd be my opinion that we would want to get that started as soon as possible, because if we wait till March 12th, that just means it'll be even longer before there is any parenting time. If Your Honor is going to order parenting time.
Yeah, we have a 5-year-old child. Mr. Merchant? Mr. Merchant, are you still there? All right, so we're going to review parenting time on March 12th at 2:30. The court's also going to order that the parties make contact with Family County Child Services and the schedule intakes for supervised parenting time. It's an agency down here in Monroe. Mr. Merchant, I'm not sure where you live right now, but you'll there's a waiting list. So, Mr. Walker, could you provide into the record the phone number of the agency to make it easy for Mr. Zonk and Mr. Merchant to call the agency, at least complete the intake, get on that waiting list. So, unlikely there'll be an opening between now and March 12th. So, Mr. Merchant, are you still there, Mr. Merchant? All right, direction reflect Mr. Merchant is emotional. All right, Mr. Merchant, we understand it's emotional. Here's what the court's going to do. We're trying to move forward, but in a deliberate, safe fashion. So the court will set this review March 12th at 2:30. You want to call in so you're real clear to hear?
Does it have to, I'm sorry, Judge, does it have to be with these elected people? He trusts Adam and Tiffany. I know that he does. Why can't it just be with them? Why does it have to be in somewhere where my son doesn't understand, where it's strange? He grows up in a very suburban lifestyle. Like, why can't it just be done with close friends and family? That's what I don't understand. Why?
Right, but first,
so diabolical about this whole situation when he doesn't even know what I'm going
Mr.
through.
Merchant, we can talk about that on March 12th. In the meantime, I want there's a master's level person that's going to observe the interaction between you.
I don't want an
Jack.
I don't want somebody I don't know observing me and my child.
If you choose, Mr. Merchant, if you choose not to contact the agency, then so be it. That's where it's going to start. If you want to have contact with Jack, that's where it's going to start. Call him, get on the do an intake in the waiting list. Hopefully, then we can expand to more family members.
I hate you.
I'm sorry.
Nothing.
The court should reflect Mr. Merchant has made a foul statement to the court. Mr. Merchant, do you want to be held in contempt? It's contemptuous conduct. The court will not permit that. So you're exhibiting that you are not a proper parent to have parenting time with this child. I understand it's emotional, so I'm going to give you the benefit of the doubt. So the court will add this order. You can I'm giving you a hearing date. I'm trying to accommodate you as much as possible. You're shooting yourself in the foot, ma'am. So March 12th at 2:30, you'll be mailed a copy of this order. The court will also order that the parties shall conduct intakes with Family County Child Services, so that when we come back March 12th, we know where you are in the waiting list. So that's a place to start.
What's the
Anything
phone
further,
number?
Mr. Jocks?
I didn't catch that, Your Honor. I'm sorry.
Is there anything further from your standpoint?
Not at this time. I was just curious if Mr. Walker was going to provide us with the phone number or if it would be in the written
Yes. He's going to put that in the written order, the phone number, so both parties can contact the agency, complete the intakes, at least get going on the waiting list.
Very well. Nothing further from us. Thank you, Your Honor.
All right. Thank you, Mr. Walker. That will conclude the Zoom hearing. And we'll see everyone back on March 12th at 2:30.
Thank you.
Thank you, Your
Mr.
Honor. I will
Mitchell, do
have
provide copies of any reports to the front of the court and to Mr. Jocks in the interim, okay? So we can move forward. All right. Thank you, Mr. Walker. That will conclude.
Thank
You can zoom out.
I'll have that updated recommendation in your queue in just a minute.
Before the court for the purpose of reviewing defendant mother's parenting time. This hearing is being conducted via Zoom. Present is Attorney Derek Jocks, representing the plaintiff father, Tyler Zonka. Mr. Zonka appears to be present with Mr. Jocks. In addition, defendant mother, Kaylee the Merchant, appears to be present. Good afternoon, everyone.
Good afternoon.
Good afternoon. The parties have conferred with Mr. Pratt for the front of the court this afternoon. Mr. Pratt has provided the court the fine recommendation that mother will have supervised parenting time with Family Counseling Child Services once she is released from Sacred Heart. And the party will appear back and forth. Court's going to keep this matter on our docket so we can reestablish a relationship between mom and minor child Jack. So we'll review this matter on May 28th, 2024 at 1:30 p.m. That is recommendation. Mr. Merchant, do you understand the recommendation?
I understand the recommendation, and I'd like to fight against that, sir, because you knowingly I don't know how to say this. Like, I mean, I have not seen my son in 8 months. I have not touched him. I have not hugged him. The last court hearing residing just required me to go to psych evaluation. Now, I provided psych evaluation. I didn't even have to do that for Mr. Jacques, and he's all concerned about diagnoses that I've had, diagnoses that I've had for 20 some odd years. I understand that. And then he wanted to say that, well, we're still afraid of the safety of the child. Now, Sacred Heart facility in Clearview, it is a women's facility for children. And I understand that it's court docketed at this other service down in Monroe County. However, where I reside now is Kimball Township. Now, I asked friend of the court if my son could come visit me, because I haven't even touched him and I don't even remember when. And then Mr. Jacques then proceeded to say that it was an unsafe environment for a 5-year-old. Now, I have my counselor, her name is Chris. What's your last name? Peltier. With me, and she can advocate for what type of facility this is. And sir, I mean, with your permission, sir, I would appreciate it if she could at least step in and explain to you where I'm at and what the facility encompasses.
Right, Mr. Burchett, the court's familiar with Sacred Heart. Will they allow a child to come in to visit?
Yes.
Yes.
Is there a common area where it's appropriate for a visitation?
Yes.
A community room or something of that nature?
When could I turn it over to Chris, because she can advocate further about what everything encompasses and what kind of counselors and people that are here supervising the children. Please and thank you.
The court is familiar with Sacred Heart, ma'am. I don't need an education about Sacred Heart. Do you have an expected discharge date or not?
Right now, it's kind of up in the air. Like, I mean, I can stay here, I believe, because I'm part of St. Clair County. How many extensions can I get, Chris?
Well, it's a wonderful facility, and obviously we just want you to be well, because Jack is 5, and yes, you need to be part of his life. Mr. Cox, is your client opposed to once a week just taking my child over there for an hour to visit with mom?
My client is opposed to that due to the nature of the facility, due to the fact that the reasons that Mr. Merchant has not seen the child in such a long period of time are caused by her own actions or inactions, not anything that we've done maliciously against her. The entire reason for these treatment programs was to ensure that she was on the right track moving forward. And we are happy that she is in this center and hopefully moving forward to be able to be brought back into their son's life. But at this point, this is a facility that's nearly 2 hours away from where my client lives. It's not been completed. There's been occasions in the past where Mr. Merchant has not successfully completed these programs. The psychiatric facility that she was in for psychiatric treatment for 10 days had concerning statements in their notes with her being discharged, saying that the patient will remain at a chronically elevated risk for harm to self and or others due to impulsivity and or substance abuse, that she had suicidal ideologies as to being admitted and while she was there. And this was from February 16th until February 26th. So these notes occurred after our last hearing even took place. So we have serious concerns moving forward, but
no, I object to that.
Mr. Merchant, don't interrupt, please.
But
yes, sir.
My client, Mr. Zonka, nonetheless wishes for there to be some development towards a relationship other than just phone calls or video chats between their son and Mr. Merchant. However, we think that Shelter Family Services is more appropriate once there's a showing that these services have been successfully completed as to the inpatient rehabilitation therapy for substance abuse that Mr. Merchant's in at this time. Once she's discharged, we're happy to start, have them supervise in the center, get reports sent to ourselves in the court, and make sure things are going smoothly, and then take it from there. But as of now, there's nothing to show that this is actually going to be completed.
Mr. Merchant, how many months have you been in Sacred Heart?
I have not been in Sacred Heart for months, but I have provided months worth of clean drug screens to Mr. Jock, which he also failed to mention. Also on my behalf.
How long, ma'am, have you been a resident of Sacred Heart?
How long? Only about 8 days, sir. Before
Oh.
then,
Okay.
Before then, I was
Sacred Heart-
hospitalized. Wait, hold on, sir. Before then, I was hospitalized for 10 days. And then I also got involved with community mental health services, Safe Horizon services, and as far as like, I am 8 months pregnant currently, sir. And I also got involved with adoption and outreach programs for my child and WIC. Simultaneously, it just sounds like that they want documentation of how the child is being taken care of. I also object to the suicidal ideation. Mr. Zonka knows himself, and the order was to get into psychiatric care, correct, sir? In order to get into inpatient psychiatric care, you have to say you are at risk to self. So did I want to kill myself? No, I don't. I have a safe place to go. I have a safe home up here in Kimball. However, I'm stabilized on meds, and I also provided 2 months of clean drug screens. So I don't understand what the issue is, except that he does not want to drive out to Memphis, Michigan, which I understand is a long drive. But I plan to be staying here for up to, 4 to 6 weeks or whatever it is. Just one visit, sir. Why is that not acceptable when they have, childcare, people with master's degrees and doctorate degrees working at this facility, facilitating women and children reunification? How is that different than what's down in Monroe, except that he's being lazy?
All right, thank
If I
you.
could, Your Honor,
Mr. Zonka, there's no substitute for physical contact between a parent and a 5-year-old child. The only way the longer there's a separation between mother and child, the more difficult it is to reestablish this relationship. Sacred Heart, in the court's opinion, is a safe facility. Obviously, this child will not be exposed to mom who's intoxicated or out of control. And obviously, if Mr. Zonka does not wish to drive 2 hours, the court understands that. Mr. DeMerchant, do you have a family member that could drive that has a decent relationship with Mr. Zonka and could drive Jack to see you once a week or every 2 weeks for an hour? Do you have someone else that you can suggest could transport him? Somebody that Jack knows. Do you have how about your mother?
Brian Burns. Brian Burns. He knows Brian Burns. Brian Burns.
Okay. Mr. Jackson, what Brian Burns is Mr. Zonka North. This Brian Burns that could transport Jack to see his mom for an hour.
I think one of the other issues that we didn't bring up because we weren't sure if it was necessary or not is that Jack is not currently aware, to the best of our knowledge, that Mr. Merchant is pregnant. And it was my understanding from previous conversations that she had intended to place this child up for adoption. And we have concerns about bringing him to see his very pregnant mother and being old enough to understand what's going on, and then not having ever the ability to see a possible sibling. If this child is in fact going up for adoption, we think that would be both emotionally and simply logically damaging to him at this point.
Objection.
I'm not sure if a 5-year-old can fully comprehend that. Is your client comfortable with Brian Burns? Does he know who he is?
Yes, I'm comfortable with Brian Burns.
Okay. What about Mr. Pratt? Any thoughts? If we have a responsible third party, do you see any harm for this 5-year-old child having some contact with mom once every 2 weeks or something? Just some contact, just a visit. It'll have to be in the Sacred Heart facility.
Your Honor, my understanding after talking with Mr. Merchant is that in a couple weeks she's planning on being back home. So I'm not sure how quickly we could get that established with Mr. Burns.
Right. You said Mr. Merchant said you're going to be there 4 to 6 weeks.
Yeah, I don't know how St. Clair County mental health access works and how many extensions I can get. However, I know this facility is willing to work with me. Even say, sir, if I switch my mind on the adoption proceedings, they will let me bring my baby back to the facility and help me with all those other things. That's unrelated. I understand that, sir.
The court's only concerned about Jack, not concerned about
I understand.
unborn child. We're concerned only about Jack.
Okay, yes, sir. I understand. I apologize for
Well, the court's not opposed to Mr. Burns transporting Jack to provide the parenting time takes place at Sacred Heart facility. I don't know what their hours are. They may have rules where they only allow it maybe on a Saturday or a Sunday afternoon. But are you able to reach out to Mr. Burns to see his availability, and he can perhaps then kind of communicate with Mr. Zonka?
The only availability would have to be on the weekends due to it being a nearly 4 hour plus round trip plus visitation or traffic, and it would affect his schooling at this point. So it would have to be something on a weekend.
Okay.
No objection to that.
All right. Well, the court will permit Brian Burns to transport the minor child to visit Mom at Sacred Heart. What do you suggest, Ms. Pratt? Once every 2 weeks?
I would ask Mr. Merchant if they have specific family times that we could set up so that the child could visit during those times as appropriate.
Any specific time that would work better?
Well, we'll work around this.
For the facility, does the facility have certain, like, for example,
No,
if your sister or mother came to visit you, is there certain visiting hours?
There is no visitation, but the children are different. That's a different accommodation for them. But they do have staff 24/7 on that can provide and assist with the transport and supervision of a child and that are trained. So
Mr.
anytime I
Merchant,
work with the court.
you need to make inquiry of staff there in terms of if someone brought my son Jack to visit me, would have to be a Saturday and Sunday, and what are the time frames? Is it 1 to 4, for example, on a Saturday or Sunday? You need to first of all determine the time frames that they would allow a child to visit you, a 5-year-old. Then you can contact Mr. Burns, and if Mr. Burns is willing to do that, then perhaps Mr. Burns could reach out to Mr. Zonka and try to facilitate a time that's good with Mr. Burns. So perhaps if the court just generally ordered that Mr. Burns is permitted to transport the minor child to visit Mom at Sacred Heart facility and on a weekend at times that is agreeable to that Sacred Heart facility.
Okay, the 12 to 5 is what my counselor has suggested. If for some reason Mr. Burns does go to Florida, and I did forget about that during the winter. If for some reason he is still in Florida, would my mother still be acceptable to Mr. Zonka as far as a child transport? My mother were willing to make that long trip.
Mr. Zonka indicated that he would be. Absolutely. Yep.
What is your mother's name? What is your
Cynthia,
mother's name?
in case, so there's 2 people that are, connected with, transporting my son so I can see him, and I'm sure that they will facilitate that. Okay.
All right. Well, the court would encourage that. So it's up to you, Mr. Merchant, to get the ball rolling. You need to first of all find out from the facility whether it's Saturday or Sunday, then reach out to either Mr. Burns or Miss Carlson, your mother, and have them contact Mr. Zonka to coordinate a time. Let your mother know.
Yeah. Saturday or Sunday. My counselor did advise me that they will work around whatever is admissible to the Mr. Zonka and my mother or Mr. Burns. Okay.
So the dates will have to be worked out to Mr. Zonka and your mother or Mr. Zonka and Mr. Burns.
Okay,
Mr.
perfect.
Zonka, obviously it's important for Jack, to have some contact, and even if it's just an hour. I understand it's a long drive, but just whatever time that person thinks appropriate, whether it's 2 hours. I mean, 5-year-old's gonna, I don't know, sometimes you get bored after a couple hours, so perhaps it's a couple hours every other week. I think whatever the parties, I'll let the parties agree upon the time frame.
Thank you.
But I do think as long as you're there at that facility and the period of time would have to occur in that facility, Mr. Merchant.
Yes.
So you will contact your mom and or Mr. Burns. If Mr. Burns is unavailable, contact your mom, have your mom then contact Mr. Zonka to line up a Saturday or Sunday afternoon. Maybe a Sunday is better for Mr. Zonka. I don't know. But the 2 of them have to work out the schedule.
It depends on his schedule. Yes, his schedule varies. So
right.
That's fine.
So
I'm satisfied with that. Thank you, sir.
All right. So Mr. Zonka, the court's just encouraging you to try to see if you can make it work for the benefit of Jack. And obviously there's gonna be someone supervising, so it's not gonna be mom alone. There'll be someone there. Whoever it's Mr. Burns or Mr. Carlson will be there, and probably also maybe a staff member. I don't know. But obviously, if anything's Obviously, Mr. Merchant will not be intoxicated or under the influence by anything at that facility. So Ms. LaPretta can just add some general language to that effect.
Yes, sir.
To the recommendation, we'll review mom's parenting time May 28th at 1:30. Mr. Merchant, be focused on yourself right now. If you want to be a mother to Jack, you've got to take care of yourself first. So be
Yes, sir.
very focused on your recovery. Don't be in a rush because it's gonna be a lifelong thing. Even if you're outpatient, you're gonna be involved in inpatient.
Yes, and that's
for the
why,
rest of your life.
yeah, that's also why I understand where Mr. Zonker is coming from with dragging his feet for me to see Jack. I do understand that it's because he does care about Jack and he doesn't want this to happen again. And, you know, I mean, like, you know, next time it's the crash, it's like, you know, that might be it. And then it's like, and Jack will remember. And I don't want my son to have build up resentments against me, sir. Yes, sir. I understand. Thank you.
So you gotta make sure the visit's appropriate.
Okay. Thank you so much.
And I'm sure other children visit at Sacred Heart. I do believe so. So you can maybe ask whether or not there's some games available. You could play with Jack.
There's tons of stuff to do here. Yes.
All right. So review this matter on May 28th at 1:30. Mr. Jocks, anything further?
Nothing for me. I just want to clarify that once Mr. Merchant is discharged from that facility, the parent time will pick back up at shelter services.
Correct.
Fine.
Yes.
Fine.
Once you're released, then it's got to be supervised. We want to make sure you're on the strong path, Ms. DeMerch. So yes, after your release, then you want to contact this agency, Family Cultural Services, and schedule the intake.
I have already contacted them to be waitlisted, sir.
Okay.
I'm just waiting on the response because it was a long wait list. So probably by the time I'm out of this facility, then it'll work. It'll go smoothly into that, sir. Yes.
Well, don't be obviously the longer you can stay there, the better, because you can develop those tools that can help you later down the road, Mr. Merchant.
Yes, sir.
All right. All right. The court appreciates the willingness of Mr. Zonka to give it a try. Then facilitate some contact between the minor child and mom. Mr. Pratt, any concerns or question about the language? I think just keep it general.
No, sir. It just states that Brian Burns or Cynthia Carlson may transport the child to Sacred Heart for visitation as agreed with father.
Okay, wonderful. Thank you.
Thank
All
you.
right, thank you, Mr. Jackson, Mr. Zonka, Mr. Merchant. The hour concludes here, and you can zoom out, and we'll see you back for a review on May 28th at 1:30.
Thank you so much, sir.
Thank you.
That recommendation is in your queue.
Yeah, Ms. Brad, do you have an address for Sacred Heart to send a copy of this order to Mr. Merchant?
Your Honor, actually, I do because I have a fax in front of me from Sacred Heart. I'm sure we could get that information to her.
Of
Wonderful, great.
2017.
All right.
It is a first
Right, thank you,
finding,
Mr.
and he does have a
Jackson.
44-day balance. I will note for the court that the friend of the court had started a license suspension regarding him, and a hearing was scheduled for later today with referee McKee. And I do believe that is probably why we got a payment of two $300 payments in January of this year. Prior to that, we had not had a payment since April of 2022.
So $600 was paid in January?
That's correct, Your Honor. We've had zero contact with Mr. Deaton. However, obviously we have a good address for him, so he must have received the notices that we were looking to suspend his driver's license, and that maybe is what finally got his attention to make a payment.
Okay, so is that hearing still transpire this afternoon with Mr. McKee?
Referee McKee was waiting to see what happened regarding today's arraignment. He is
Okay.
aware that Mr. Deaton is incarcerated in the jail.
All right. Mr. Deaton, are you currently employed?
Yes, so I'm in between companies. That's why I haven't made a payment in 2 weeks. I'm switched over companies. I'm a truck driver, and I was actually supposed to start today, tomorrow now, with Horizon Freight Systems.
Horizons or Verizons?
Horizon, HOR.
So, of course, the significant question is how much can you post in terms of bond, Mr. Deaton? You got 44 days over your head. The court's going to impose a jail sentence, but we'll give you an opportunity to post a bond. And I'd like to see if you can post that bond so you can get out and go to work tomorrow.
I won't be able to pay a bond until next Friday when I get paid.
Well, unfortunately, it doesn't work that way.
I've been off
You,
for 2 weeks.
just reach out to family and friends. You can pay them back when you get paid next Friday.
No, I wish it works out that way, but
So again, how much can you pay in terms of a bond? If you can't, if you say zero, then I'll just set amount.
I can't pay anything right now. I don't have any money. I've been off for 2 weeks.
Okay.
I haven't had a check in 2 weeks because I'm
You
switching.
don't have any family or friends in the area?
My kids, but they don't have the money right now.
Right. Well, again, you've had zero contact with the front of the court, Mr. Deaton, and that's a problem. So again, when you say you've got a job, it's the court's hard pressed to accept that statement. Number 6, what's your recommendation?
Your Honor, my recommendation is 10 days immediate jail or $1,000.
Mr. Deaton, can you come up with something less than $1,000?
I might be able to come up with 500 if I make some phone calls. I might. That's if my brother can make it down here.
Does your brother live in Dundee?
Well, he lives out in Blissfield, but he's out of town right now. He works all over the state of Michigan.
All right, Mr. Deaton, because of the fact that you made some payments in January, you indicate you've got a job, but the court will require you post a $500 bond rather than $1,000 being recommended. So the sentence of this court, is there anything you want to say before I post sentence once again?
No, Your Honor. I mean, I intend on paying this. I was off on medical for quite a long time. I have to use a walker. I'm using it now here in the jail. I was able to get back to work in December. I was able to start paying in January. Now I'm just switching companies, but I do have to use a walker because of my leg. I can't. I don't know if you can see the walker or not.
I can.
I am a medical. I'm dealing with a lot of health issues, and that was one of the reasons why I wasn't able to get it squared away.
Well, Mr. Dean, you've been sitting on your hands. If you keep in contact with the front of the court, even by phone calls, in case we're let them know what's going on, I'm in medical. They're going to work with you, but you've ignored the contact with the front of the court. That's why you find yourself in this position. So the court's going to order you to serve 44 days in Monroe County Jail as follows: 10 days immediate. Keep in mind, you got 34 days still hanging over your head. 10 days immediate, but you can be released immediately upon posting a $500 cash bond. So give me the benefit of the doubt. Make some calls. If they post $500 today, tomorrow, you can avoid the 10 days as soon as you post a bond. It's got to be a cash bond. It's going to apply 100% towards your verges, not going to fines and costs. 100% towards your verges to get below the $7,000 mark. Finally, I'm going to give you dates. Come back for review. It'll be a Zoom review, Mr. Dean. So if you're driving, you zoom in and contact and talk with Miss Hicks. Let her know what's going on. You got to start making regular payments. You just can't wait till they suspend your license. So with this, Miss Hicks, in terms of with Mr. Dean claiming he's got a job of driving for Verizon, the court suggests Mr. McKee that we hold off suspending driving privileges this time so he can secure that meaningful employment.
Yes, Referee McKee generally does not move forward with a suspension if a bench warrant has been cleared. And he'll see the notices from today. So this will he will either deny the FOC motion or do an adjournment depending on his review.
Okay. All right. So Mr. Dean, we're going to try to keep you the valid driver's license, but you've got to keep contact with the front of the court. Just do not ignore things. So it's again, it sounds it's 10 days in jail or a $500 bond. So get that reach out, make some calls, see if you get that $500 bond post as soon as possible. You'll be out the next day or so, as soon as you post that, right?
Yep. Yes, yeah.
Finally, we're going to send you an order, send a future review date. You can appear by Zoom. Ms. Hicks, what review date would you recommend?
April 2nd at 1 p.m.
I wanted to ask also why that amount keeps rising. Because that 600 under 7,000, and I was actually under 7,000 before, and I don't know why the amount keeps rising.
Your Honor, when he's released from jail, he can come over and meet with his caseworker. They can provide him an account summary going back however far he would like, so that he can see where all the charges come from.
Do you understand that, Mr. Dean? Again, it should not be rising, but again, I can't answer that question. You can come over in front of the court, meet with your caseworker.
All right.
And they can give you a printout. They can answer your question. Okay, so Mr. Dean, you are to appear before Ms. 6 for review April 2nd, 2024, 1 p.m. And you can appear via Zoom. A copy of the order will be emailed over the jail. One will also be mailed to you at your address on Emerald Circle in Dundee.
Yep.
So make some phone calls, $500 or 10 days, all right?
Yes, sir.
Any questions?
No, sir.
All right, very good, Mr. Dean. You're all set. Thank you, Ms. X.
Thank you, Your Honor. I'm uploading those orders shortly.
If he's gonna like that. Ma'am, do you have someone to watch your child just for the next 10 minutes? Alicia.
Okay, sorry, I had the time wrong earlier, so I didn't take her to the babysitter.
Okay, thank you. Court is now in session, middle of page 2, Robert Moss versus Tiffany Hudak.
Record this matters before the court for the purpose of reviewing defendant. I'm sorry, the defendant mother's parenting time. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, representing the plaintiff's father, Robert Moss. Mr. Moss is present, and defendant mother Tiffany Budell is also present. Good morning, everyone.
Good morning, Your Honor.
The parties have conferred this morning with the front of the court. Court has received the following recommendation regarding parenting time for Shiloh, who's now 17 months.
Yes, Your Honor.
Recommendation is that I'm sorry, this is actually a review of a plaintiff father's parenting time. It's been previously supervised by defendant mother. I stand corrected. The recommendation is that father shall continue to have supervised parenting time at Chuck E. Cheese on Dix Road in Southgate on Sunday, this coming Sunday, 12 noon to 4 p.m. Then Wednesday, 5 to 7, and Friday, 4 p.m. to 6 p.m. Mother will continue to supervise. And the matter of custody and child support, custody and parenting time shall be referred to the front of the court for formal investigation and recommendation. Will provide all income within 7 days. I don't see where it's recommended that child support would be referred to the front of the court for recommendation, but in any case, party shall provide all income within 7 days. Both parties shall complete the small program, and neither party shall disparage the other or discuss the case in the presence of a minor child. And finally, the parties will appear back for court to review parenting time on April 2nd, 9:30 a.m. That's recommendation. Good morning, Mr. Pratt.
Good morning, Your Honor. For clarification purposes, the child support was referred in a previous order. I didn't have any information to be able to process that recommendation. That's why you have the 7 days.
Understood. Thank you. All right. Ms. Hills, is this recommendation agreeable with your client this morning?
Yes, it is, Your Honor.
So this parent time for dad, will this be until further order of the court every Sunday, Wednesday, and Friday?
It will be. The previous order gave the parties an ability to communicate and adjust those days as necessary for their schedules. We would, I think, given how things went this morning, sticking to the order as much as possible, I think would be beneficial. I think Ms. Pratt would probably agree. But there is a little bit of wiggle room. The intent is that he have the 3 contacts per week. And he is definitely making progress in building the relationship with Shiloh. She was waving at him while we were in the breakout room for the period of time that she was there, which wasn't long.
All right, wonderful. All right, Ms. Budell, do you understand the recommendation this morning?
Say it one more time, Your Honor. I'm so sorry.
Do you understand the recommendation this morning?
Yes, Your Honor.
Do you have any objection to the court adopting this recommendation as an order of the court?
Not at this time, Your Honor.
Okay, wonderful. Ms. Hills, do you want to voir dire your client at all? He obviously is participating in the discussions with Ms. Brad.
No, that's not necessary this morning, Your Honor. Thank you.
Okay, continue to work together, Mr. Moss and Ms. Budell. Obviously, it's important that Shell have a good relationship with her dad, and that needs to be encouraged by my mom as well. So the court will adopt the recommendation, and this matter will be back on the court's docket then on April 2nd, 9:30 a.m. For the record, this matter is before the court for the purpose of reviewing the father's parenting time, in addition to address the plaintiff's objection to a child support recommendation. This hearing is being conducted via Zoom. Present is Attorney Christine Hills, representing the plaintiff father, Robert Moss. Mr. Moss is present. In addition, defendant mother Tiffany Budell is also present. Good morning, everyone.
Good morning, Your Honor.
Parties have conferred this morning with Mr. Walker from the front of the court.
Yes, Your Honor, I'm in the process of trying to get that recommendation to you right now.
Court would also note for the record that the last time the parties were before the court, February 13th, the court did refer the issue of custody and parenting time to the front of the court for formal investigation recommendation. The front of the court, Catherine Scott, has recommended that the parties continue joint legal physical to defendant mother. Court has now received the recommendation of Mr. Walker this morning, which is as follows. Parenting time shall continue as previously ordered by this court. Father's parenting time shall be supervised by Family Counseling and Shelter Services. Each party shall pay for their own intake. Mother shall pay for all sessions. The defendant's objection to the child support recommendation scheduled with referee McKee on April 16th, 2024 at 9 a.m. be vacated. Further, with respect to child support, Ms. Walker is recommending that commencing January 1st, 2024, that the plaintiff father pay child support in the amount of $1,452 per month.
Your Honor, there is one. I'm sorry, Your Honor. There's a section. There's a section that I forgot to put in. I apologize. There's a section that I forgot to put into my recommendation. Mr. Moss is stating that he may have given direct payments to the other party for child support. And I was going to add there that if he can provide proof that there were payments directly paid to her for January, February, and March, that the friend of the court would give credit for that. So I need to add that to my recommendation. I apologize for that, Your Honor.
Okay, thank you, Mr. Walker. It's further recommended that uninsured medical expenses be shared as follows. Plaintiff father paying 65%, mother paying 35%. That is a recommendation. Of course, where we have an 18-month-old minor child here. Ms. Sills, with the addition of the language suggested by Mr. Walker, that Mr. Walsh received credit for any direct payments made to Ms. Budell upon providing proof. Is your client agreeable with this recommendation?
Yes, Your Honor. It's my understanding with respect to the parenting time recommendation that the current order regarding parenting time would continue only until the Family Counseling and Shelter Services is able to accommodate a visit. I know that they have a wait list of several weeks at least at the moment. So I'm not sure if Mr. Walker's intent was that the supervised visits with mother continue once family counseling is involved, or that those stop once family counseling is involved.
The intent was that once Family Counseling and Shelter Services begin supervised visitation, mother would no longer have to supervise.
Okay, thank you. And I may have just misheard the reading of the recommendation. So thank you for that clarification. With that, Judge, we are not objecting to Mr. Walker's recommendation today.
Okay, so if the court understands it correctly, Ms. Sills, that the current parenting time for dad, which is supervised by mother at Chuck E. Cheese's on Sundays, noon to 4, Wednesdays 5 to 7, Fridays 4 to 6, that will continue until such time as the supervised parenting time will commence at Family Counseling and Shelter Services, and at which point in time all supervised parenting time would be at that agency.
Yes, and I would suggest and hope that the parties contact the agency as soon as possible to get on the wait list so that there's not any delay.
Yes. Can you provide the parties with a phone number?
I will.
Okay, so Ms. Budell, both you need to contact the agency as soon as possible to schedule your intakes. And that's the first step to getting on this wait list. All right, thank you, Ms. Hills. And Ms. Budell, do you understand the recommendation this morning?
Yes, I understand.
Okay, do you have any objection to the court adopting this recommendation?
Yes, I do.
Okay, what's your objection?
My objection is I don't want it if I have to pay for it. I'd rather supervise the visits myself, even though it's I don't want to take the money away from my other 5 children. Like, I have 5 children. He has just Shiloh. Like, I don't want to pay for his supervised visits because he's lying. You know what I mean? I don't want to.
What do you mean he's lying? What does that do with parenting time?
Because that's what happened, Your Honor. We both filled out the investigation and all of. Well, he didn't even fill out.
Why don't you sit down, please? You're walking
Sorry,
around
I
the
pace
room
when
with
I
the
get
phone in front of
nervous.
your
I'm
face.
sorry. I
Can you
pace
sit
when I
down,
get nervous.
please?
Yes. So we both filled out the paperwork, and then we got the order for child support, and I objected to it because it wasn't accurate. I make $5,000, and it said he makes $6,000 a month. Well, that's not accurate at all. So I objected to it. Then 2 days later, they object to it, saying that he makes even less than that. And I'm just like, I don't feel like it's right that I have to keep being so nice and supervising the visits and, all this stuff. And he's just going to keep lying and trying to cheat Shiloh. So that's what I said. I
Sworn
said,
testimony from Mr. Moss this morning. So what is he lying about? His income?
yes, Your Honor. If they're saying I make $5,000 a month, how does he make $6,000 a month if he has all these houses and all these bills? And we have to use our common sense, not just the little bit that he provides of information he provides. So I objected to that. So when I objected, then they turned around and objected, which didn't even make sense because you know what I mean? If you look at his assets, I turned in some of them as proof to friend of the court. I turned in a lot of evidence, I feel like. And then he objected to it, but I'm already coming out of money doing all these supervised visits for him, and he's going to still try to cheat Shiloh. So that's why I said, I don't want to keep supervising the visits if he's going to keep trying to cheat my daughter. And then he said he don't want to pay for daycare so that I can work. He wants to be the babysitter. Well, I can't depend on him because he's evicted me and my kids before. So clearly he don't care if we have a roof over our head. So me and my kids can't depend on someone like that to provide childcare for the family. This just didn't go good today at all, Your Honor, at all.
Well, we actually have a lot of anger inside you, Ms. Bedell, and I understand your frustration. But again,
yeah, you're
we've got two
supposed to
different
be
issues.
honest.
One is parenting time, one is child support. You object to everything, correct?
The initial friend of the court recommendation that I saw, I didn't object to that. But then when Mr. Walker said that if I want supervised visits through the court, I would have to pay for it. Well, now I'm taking money away from the other 5 kids. I can't do that. So I'll just continue to be humiliated and supervise the visits if we could do that. But I wanted his income looked into because that's not accurate, Your Honor. And I'm not coming to this court lying about anything.
Let's deal with one issue at a time, ma'am. There are two different issues. Ms. Hills, if she doesn't want to pay for the visit, I don't know. First of all, what are the costs for the visits? Is it $30 a session?
$25 or $30 a session, I believe.
Okay. And if she doesn't want to pay that, what about continuing if mom wants to take time and supervise 3 days a week? Is your client opposed to that?
Mr. Moss, in light of what we spoke about with regard to family counseling and shelter services, are you willing to either continue with Ms. Bedell supervising your visits long-term, or at least as long-term until the court orders at some point that your visitation should be unsupervised? Or are you willing to take on some responsibility for the payment at family counseling and shelter services of the $25 to $30 a session?
I definitely don't have no extra money at this time. So I guess we'll just have to do what we have to do.
In terms of having her continue to supervise visits?
Yeah.
And you've indicated that there's not this sort of vitriol during the visits as in regard to you, that this is, your daughter is insulated from this back and forth between the two of you that we've seen today?
So far, but after today, you know, it's like she said, she's being humiliated. And then all I see is this is about money. All this is about money.
Mm-hmm.
Okay. Ms. Hills, in further consideration, there is some value to dad having time with the minor child without mom being present, a third party.
I agree.
So what the court's inclined to do is each party shall pay for their own intake, and they should contact the agency as soon as possible, and the party shall share equally the cost of the sessions. We're going to review this in perhaps 6 weeks. And at some point in time, hopefully we'll get positive reports from an independent third party. Maybe we don't need the supervised parenting time. That's the hope, the direction we need to move in, is to limit the supervised parenting time. And I think it's appropriate to observe the relationship between dad and minor child without mom being present, so that we can make a determination whether or not dad is capable of providing caring for this child without mom or some other supervisor being present. And we establish a relationship between dad and the child, so the court believes that would benefit the minor child. We're going to continue the supervised parenting time with mom supervising on Sundays, Wednesdays, and Fridays as previously ordered until such time as Family Counseling and Child Services is available. I'm going to schedule supervised parenting time sessions, at which time hopefully be every week, whatever that agency can accommodate. And that'll be just dad and the minor child. And the party shall share equally shall share the cost of those sessions. So the court's going to modify the recommendation in that regard with respect to child support. Mr. Walker, can this be referred for formal investigation recommendation? Child support and parties are required to submit financial documentation to verify income. Ms. Bedell is disputing the reported income of Mr. Moss. I don't have the benefit of a recommendation. And I know it's subject to recommendation. It's not in the court file. I have no idea who did the recommendation, what kind of information they used.
Your Honor, there was a formal recommendation done. My client provided a tremendous amount of income information. And I'm looking to see who did the recommendation.
Stephanie LaPrea did the recommendation.
I did the recommendation, Your Honor.
Okay, so there's been signed statements signed by the parties in terms of verifying their income, correct?
Correct.
Right. So Ms. Bedell, you can go to the front of the court and get a copy of the information that Mr. Moss signed, and if you find that he is misleading the front of the court, that's basically to come back and address this thing further. But at this point,
100%. Oh, I'm sorry. I thought you asked me a question.
But at this point in time, the court's inclined to adopt the recommendation until you can provide other allegations that his income is not accurate. He's provided written documentation in the front of the court, and that's the front of the court has made this recommendation based upon the review of the written information provided. Presumably did that include the last year's tax returns, Ms. Hills?
That is my understanding, yes.
Okay.
Your Honor, the last 3 tax returns were included in the packet that was turned in.
All right, thank you. So the front of the court has all the financial information necessary to make this recommendation, Ms. Bedell.
So he lied to the IRS and now we have to just accept that? Is that what we're saying? Is that what's going on? Because ask Mr. Moss how much he pays in mortgage payments a month.
If you believe he's committing fraud, you can contact those agencies and allege that.
I just want Shiloh to be properly provided for. If he's paying $10,000 in mortgage payments right now and he used to pay $20,000, he can't only make $6,000 a month if just his mortgages cost $10,000. That's where my anger and frustration is coming from.
In front of me, Ms. Bedell, the court suggests is contact legal services or attorney and they can petition the court and show that Mr. Moss is understating his income is ability to pay.
Why do I have to have an attorney to do that?
Tax returns.
That's what I want to do, Your Honor.
Okay, all right. You have the right to do that. You can still petition the court to challenge us, but you need to have some proof that there's been fraud on the part of Mr. Moss in terms of his financial situation.
I guess I'm not understanding what I'm doing wrong then.
Provide documentation that he's committing fraud. Some proof rather than just allegations.
Where's like just Big Emmett, he sold for $420,000 and he owned it outright. So I'm not under like he's getting ready to sell Breast Road. He's gonna clear 300,000 on it. I mean, I'm not understanding. He sold West Road, made 100 something on that last year too. Like it's big money. So I'm not understanding how he only makes 1,000 more a month than I do. I'm not understanding. You see,
Presuming that's all been disclosed in his tax returns. You could have had significant debt on those properties too. I don't know if you're.
But that wouldn't be. But that's not
$100,000.
That's not accurate.
Okay. Well, you can conduct discovery, Ms. McDowell. You can submit interrogatories, request for production of documents to Mr. Moss, and you can get a copy of those things.
Yeah, Your Honor, I'm sorry, I'm not familiar with court. I want to bring in my evidence, and I want to present my evidence. I don't understand like this remote stuff. I want to like dress up and come to court and present my case.
You present that to the front of the court. I mean, the front of the court is also has already conducted the investigation. That's when you should have provided all that information.
So that's what I did, and then I objected to that when they did the discovery because it wasn't accurate. So sorry, I'm starting to pace. Let me sit down. So I objected to that, and then I want to come into court and present my evidence.
Okay. Well, we'll leave on the hearing then. You can appear for Referee McKee on April 16th at 9 a.m. We'll keep that on. You can come in,
yes,
McKee, with all your documentation. So, Mr.
Yes.
Walker, we'll leave that hearing on for Mr. McKee. The court's inclined to adopt the recommendation this morning. If Mr. McKee, you can address it further on April 16th at 9 a.m. So we'll leave that date on, Mr. McDowell. You can come in person, talk to Mr. McKee, and provide him with the documentation and show him proof that Mr. Moss is submitting fraudulent tax returns, and they make a complaint with the IRS.
Your Honor, I am not available on the 16th. That's a travel day for me, so I can't even promise I could stop somewhere and join in a hearing.
Okay.
So I'm wondering if we could get a new date before Mr. McKee from front of the court. I'm certain my client is going to wish me to be there.
Okay. Mr. Walker, do you have access to Mr. McKee's schedule? Can we take a break? You can call him and we can change it from April 16th to a different date.
Your Honor, we can put that on April 30th at 1 p.m.
We'd be available then, Ms. Hills?
I can make that. Judge, I've got a 1:30 with you that day. So as long as you're okay with that, I'm okay with that.
Absolutely.
Okay.
Okay.
Your Honor, I can add that to my recommendation. Stephanie, can you give me the date one more time?
April 30th, 1 p.m. with Referee McKee.
Thank you, Mr. Pratt.
Your Honor, the only other thing is because they're both self-employed, Mr. Moss provided the last 3 years, Ms. Budell did not. So we would also need the 3 years for her as well if we're going to be making accurate recommendations to the court.
I don't have 21s. I don't have 21s. I gave everything. I didn't file in 21. I gave everything.
Did not file in 2021?
No.
Why? Because you had no income?
No, because I didn't realize until I just had to submit my paperwork, but it's probably because my company changed names mid-year. So I probably missed it because I probably got one from Landmark Realty and then one from Compass Realty and just, I don't know, maybe I got confused or something, but I just realized that when I had to I don't turn in my income for anything else. So I didn't realize it.
There should be a social security statement available. She should be able to set up an account online, which will give a history if there was withholding done, which will give a history of the.
I'm self-employed, so it doesn't, but I just have to find my 1099 from Landmark and then my 1099 from Compass because my brokerage changed names halfway through the year in 2021. So I'm guessing that's what happened.
Well, each of those brokers should be able to provide you with the documentation of your income while they were your broker. So reach out to those brokers And
Yep,
try to
yes.
secure that information, Ms. Vidal, for this hearing on April 30th at 1:30 p.m. You can, 1 p.m., April 30th, 1 p.m. We'll put this in this order this morning that your objection to the child support recommendation can be heard by Referee McKee, not on the 16th, but rather the April 30th at 1 p.m.
Okay.
And you need to get that documentation together. Ms. Hill suggested go online, Social Security, they can have that information. Obviously, if you had taxes, I don't know if you're a broker, if you're self-employed, they would not have withheld any taxes, but you have an obligation to still pay tax on your income.
Your Honor,
Secure that documentation. At
once you
this
file
point in time, the court's going to order that commencing as of January 1st, 2024. And Mr. Ross paid child support $1,452 per month. Parenting time will continue as previously ordered, namely, mom will supervise for 3 days a week at Chuck E. Cheese's until such time as there's an opportunity to have supervised parenting time between dad and the minor child shallow with family counseling child services. Both each pay your own intake fee, and then the parties should share equally these fees for the sessions. And the final send this for review in about 6 weeks. Hopefully, we've got some reports from that agency, Ms. Hills.
Your Honor, Mr. Walker's indicated that the wait list is currently about 6 to 8 weeks.
Okay, so maybe 8 weeks then.
Wednesday, June 5th at 8:30.
I can do that.
So if you could put that review date in the recommendation, Mr. Walker.
Yes, Your Honor. What time was that?
8:30, June 5th.
Thank you.
So please contact Angie today. Get on the sooner. Both of you need to contact them today and make that appointment for the intake to move this matter forward. All right, anything further this morning, Ms. Hills?
No, Your Honor.
Ms. Vidal, anything further?
No, Your Honor.
Okay, so all right, the court will adopt the recommendation as revised. You'll be mailed a copy. We'll see you back in June then.
Thank you. April?
Right. Well, yeah, well, that's gonna be before Referee McKee. You're not gonna be before this court. You're gonna be before this court for review in June, review the parenting time.
Okay, Your Honor.
Your objection to the child support recommendation will be heard by Referee McKee in person on April 30th at 1 p.m. rather than the 16th.
Okay.
Okay.
Awesome.
That will close this matter before the court for purpose of reviewing parenting time. This hearing is being conducted via Zoom. Present is Attorney Kimberly Kuhn, representing the plaintiff mother Rebecca Bear. Ms. Bear, please be present with Ms. Kuhn. In addition, Attorney Leslie Carr is present, representing defendant father Bradley Blossom, and Mr. Blossom is present. Good afternoon, everyone.
Good afternoon, Your Honor.
The court is aware that a 14-year-old child here and the father and the child were to engage in counseling with Gene Cook for the last order. The recommendation that the court has received in front of the court this afternoon is that the father shall FaceTime with the minor child and his half sibling, Mary and Braxton, every Wednesday at 7:30 p.m. Once a month, the child shall spend time with Mary Braxton and Uncle Danny Scharf. Court doesn't have a jurisdiction over those people. A little confused, and further recommend once a month, father shall go to dinner with the minor child, Mary Braxton, and stepmother Brooke. Father and minor child shall continue counseling once a month. The minor child shall continue individual counseling. Mother or father shall initiate FaceTime calls. Mother shall provide all transportation for the minor child. The party shall communicate regarding coordinating the dinner time with Uncle Danny and counseling. That is the recommendation. The court doesn't really understand it. What does the court have to do with Mary Braxton and Uncle Danny?
Your Honor, I believe the previous recommendation was that the party should follow the treatment recommendations of Ms. Cook. Ms. Carr and I had the opportunity to speak at length with Ms. Cook, and she had made those recommendations. Mary and Braxton are the half sibs of Isaac, and it's important to Isaac that he also has that relationship. Danny is willing to facilitate that, and it gives the siblings a one time a month to spend time together. We're trying to really work on repairing the family, and the family does consist of a stepmother and 2 children. So based on Ms. Cook's recommendations for treatment, she believed that this was important and that all the parties would be willing to comply with those recommendations.
Thank you. So in other words, the minor child Isaac there's a certain comfort zone when he interacts with dad, with Mary and Braxton being present. Is that correct?
That is.
Okay. All right. And thank you for the explanation. Ms. Cooney, are you asking the court to adopt this recommendation this afternoon?
We are, Your Honor.
Ms. Carr, is your client likewise asking the court to adopt this recommendation?
Yes.
Okay, there would be no further review at this time. Is that correct?
That is correct.
All right. Ms. Kuhn or Ms. Carr, would either of you like to voir dire your respective clients regarding this recommendation?
No, not at this time.
No, Your Honor, not necessary.
All right. All right. I'd like to thank Mr. Walker, Ms. Cook, and of course, attorneys Kuhn and Carr for helping facilitate this resolution that we can move forward. Hopefully, now will Mr. Blossom and Isaac continue counsel with Gene Cook? Will that continue, Ms. Kuhn?
1 time a month, and that's in the recommendation as well. And Isaac will continue individually counseling with Ms. Cook as well.
Okay. Well, and hopefully Ms. Cook at some point in time can facilitate a normal relationship between the dad and son. Isaac will be an adult before we know it, and that's important. All right, that's wonderful. Do we need to put that in the order, or everyone agrees that Mr. Blossom will continue counseling with Gene Cook? Certainly, it's in his best interest to do so.
I thought it was in the order.
The prior order.
No, I thought it's not in. I don't have a copy of what you're looking at, Judge, but I thought that.
Oh, it just says the child shall continue individual counseling. Father and minor child shall continue counseling once a month. That comment makes reference to Gene Cook, correct?
Correct.
Okay. But it wasn't joint counseling? Wasn't it Dad, Isaac, and Miss Cook?
Yes.
It was as well as individual. So Isaac sees Miss Cook individually, and then once a month, Isaac is going to see Miss Cook with Brad, with his father.
Okay.
And
right.
Brad has had
father. Okay. All right, that's understood then. It does say father and minor child shall continue counseling once a month, and the child shall continue individual counseling. So I think that covers everything. Well, thanks for the explanation, Ms. Kuhn. Okay. Anything further this afternoon, Ms. Kuhn or Ms. Carr?
No, thank you.
No, thank you.
All right. Thank you all. And Ms. Bear, Mr. Blossom, continue to work together to facilitate the relationship between Isaac and his dad. It's real critical. All right. The court will adopt the recommendation. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, you too.
Thank you, Judge.
Thank you. Thank you, Mr. Walker, for review. Same is being conducted via Zoom. President Attorney John Danielski representing the plaintiff mother, Carolina Rios. Ms. Rios is present. Is Nicholas Poor present? It appears that he is not. This matter was scheduled for 2:30, is now 2:45. And this review date was set back on December 20th, 2023, at which time Mr. Poor was present. Ms. Rios, do you have can you try texting Mr. Poor and remind him? They're waiting for him.
You're muted.
You're muted, Ms. Rios. Do you have his do you have a cell number you can text him?
Lower left, Caroline.
There we
go.
go.
Your Honor, we thought you wouldn't show today based on, I had attached a text to a brief. It didn't surprise us that he's not here today.
Ms. Rios, do you have a phone number? Can you text Mr. Poor and tell him that we're waiting for him?
I only have the app close number. That's all I have. That close app.
Okay. Well, that's going to show up on his cell phone, right?
As far as I know, yes.
Yeah, but let him know that we're waiting. There's a Zoom court appearance right now, and he needs to check in and forthwith. maybe forgot about it.
He was here.
I'm sorry,
He was.
Mr.
He had court last week. He called in fine.
Not sure what you mean by using court last week.
There's a
Yeah.
show called Child Support, I believe, yeah.
Okay, all right. But just remind them if you could, please, give me a few minutes if you get send that message, tell them that perhaps you got court dates confused. And I'm sorry, Mr. Danielski, you indicated that I'm sorry, you're not surprised he wouldn't appear because of what reason?
Well, he had sent a text, Your Honor. I had filed a brief with the court, and the text stated, I'm not going to force Julian. He's talking about his daughter, Julian. I guess that's the nickname for her. I'm not going to force Julian to talk to me. My mom talked to her, and she didn't want to do New Year's Eve. If she wants to speak with me, she can call or text me. I'm available. I'm not going to force it. So he had sent that. So I'm just saying we're not surprised that he's not here.
Okay, let's give a few minutes. Is the minor child still actively engaged in counseling with Dr. Yeager?
Yes.
Okay.
Yes.
And, the court has not seen a report for it. Last report was August. It's now February. Do you have any updated reports from her, Mr. Danielski?
No, Your Honor, I just got in this case. Caroline, I went through the file that everything you gave me. I don't believe I have anything since August. Is that correct?
Correct. Yeah. I mean, she sees her every 2 weeks. I mean, if you want, I can have her have an updated report, but as far as I know, everything's the same.
Okay, well, let's see if Mr. Poor appears. It would be helpful to have an updated report. Obviously, we have a child that needs to have a relationship with her dad, and the court was going to suggest maybe supervised parenting time with the paternal grandmother. Juliana does have a relationship with the paternal grandmother, is that correct?
Yes, she sees her.
I mean, what about supervised parenting time with the paternal grandmother? If the court recalls, Mr. Poor's on the waiting list. Ms. LaPrada, is that correct at Family County Child Services?
Well,
No,
what
not
happened, Your Honor? Yeah, I'm sorry, Ms. LaPrada, if I didn't mean to interrupt you.
Family
You want me
Counseling
to-
and Shelter did intakes with both parties, and also it looks like had information from Juliana and Family Counseling and Shelter due to having to file a 3200 with Child Protective Services, did not proceed with supervised visits, Your Honor.
And that with 3,200 is what, because of a disclosure made by the child? Or
Correct.
statement made by the child?
Yes, 3,200 is the application of abuse or neglect with Child Protective Services.
There was also something I believe I might have attached it. If not, I think it's in the. Yeah, my Exhibit D, Your Honor, is a report from Family Counseling and Shelter Services, and he also was very rude. He used the F word at the office at Family Counseling, and they also noted that. They said, due to the complexity of this case, along with the disrespect Mr. Poor has shown staff at this agency will not be conducting supervised visitations for this case.
Okay. All right, the court does recall that. Ms. Rios, any response?
I have not heard anything, no.
Okay, so you text them through the app post, is that correct?
Yes.
Yeah, message them, okay. So I'm sorry, Mr. Poor what was the date of the child support hearing that Mr. Poor appeared at last week, Mr. Danielski?
Carolina, what date was that?
February 6th. It was just child support normal hearing every month to monitor payments that he's behind on.
It appears from the last order entered by this court back December 20th to indicate father can have therapeutic supervised parenting time at Family County Child Services if they'll take on the case. Obviously, they will not take on the case, so that's no longer an option.
We're not certain. That letter that I had attached was a while back. The thought was maybe they would reconsider. That was August 23rd, that letter. I'm sorry, Your Honor, July 12th. That was last summer. So the thought, I wasn't there last time, but I believe that was the thought, that perhaps they would reconsider.
Yeah, I do recall that's an old letter. So obviously when we appeared in court in December, Ms. Sills was representing Ms. Rios, and there was some thought that they may reconsider. Mr.
Yeah,
Pratt, do you have any more information about that agency taking the meeting with Mr. Poor and the minor child?
Your Honor, Mr. Poor would have to reach out to them, and at that time, they would reconduct the intakes, and they would have to make a determination from there. Mr. Danielski also attached a letter from Dr. Fike that looks like that they don't recommend that at this point, but Mom did agree to leave his phone calls and any family counseling in place if family counseling would agree to those visits, Your Honor.
Okay. You said Dr. Fike, you mean Dr. Yeager?
Yes, Your Honor.
Okay. Okay, so you prepared, I do thank you, Mr. Pratt. I do note now that you did prepare a recommendation which shows that Mr. Porfeld Peer recommends the current order remain in effect. Do we need to spell it out for the benefit of Mr. Poor? I don't know if he's gonna remember the last
I mean, we could put something in
order.
there that, we encourage him to reach out to Family Shelter. But like that a text I attached a copy of it via AppClose. It was a message to her. He said he wasn't, well, he did say actually at the end of the text that he would reach out to family counseling. He did say that, but we haven't heard if he's done that. He said, I'm looking for counseling centers this week. That was, a while back that was shortly after the last court date. But Carolina, have you heard from him about any counseling centers?
No, December 26th. It was December 26th. We haven't heard anything.
Ms. Rios, the last order of the court to indicate father could initiate phone calls to the child through your app close on Tuesdays and Fridays. Has he done that at all?
Only December 26th. That's it.
Okay. Okay. All right. Right. Obviously, Mr. Porsche should have a copy of that last order. It was mailed to him, so the court will simply adopt the recommendation today that the current order remain in effect. So, Mr. Poor, if he makes inquiry, he's got to contact the agency. Hopefully, he will communicate with Joanna through AppClose. That's what the court would hope. All right. Anything further this afternoon, Mr. Danielski? No need to schedule a future review date. We don't know if Mr. Poor will participate, but Ms. Rios, your daughter would be well served if you could try to help facilitate and mend that relationship. She needs a father in her life. I understand there's some issues right now, but to the extent you can help work through those, that's best serving your daughter.
Nicholas Poor is zooming in now, Cindy said.
Oh, I'm informed Mr. Poor is appearing right now.
Shouldn't be able to. Wait, right?
And we'll put him in.
With Stephanie.
Well, that's just. Yes, I want to see if he's forgot about this.
Almost 3 o'clock.
He's having trouble with his phone, I'm informed. Looks like we have an agreement on.
We do with Patrice.
Yes, let's maybe call that. We're going to put your break room for just a minute. I have one other matter that's real quick, and they've got an agreement. Mr. Poor is attempting, I think he's going to phone in. For the record, this matter is before the court on the plaintiff's motion to modify parenting time and other relief, as well as the defense's motion to dismiss plaintiff's motion to modify parenting time. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff mother, Kelly Lavoy Colasar, and Ms. Lavoy Colasar is present with Ms. Zagorski. In addition, Attorney Alexis Spencer is present, representing defendant father Nicholas Alexander. Mr. Alexander is present. Good afternoon, everyone.
Afternoon.
First of all, with respect to the defense motion to dismiss, the court will deny that motion. Certainly a passage of time, Ms. Spencer, 6 years is certainly a circumstance that would allow the court to consider parenting time modification. So the court would leave open the prospect of modifying parenting time. The court's not saying parenting time would be modified, but certainly the passage of time, I think, is sufficient to satisfy the low standard for modifying, reviewing parenting time, I should say. Anyway, the parties have conferred with Ms. Patrick. Ms. Patrick has indicated that the parties shall mediate with Mr. Walker on March 21st, 2024 at 8:30 a.m. regarding the modification of parenting time or possible modification of parenting time. And further, that the issue of child support shall be referred to the front of the court for investigation recommendation. Should we not wait to address child support until we have a parenting time order in place?
Your Honor, that's a really good question, and Ms. Patrick asked the same thing. My thought was just to get it started, if we at least have the parties' income at mediation, Mr. Walker could always go in and run it if there were an agreement to change parenting time. I don't know. You know, my motion asserts that the current schedule is contrary to the children's best interests. And part of the reason that I asked that parenting time be modified to every other weekend is because, as I've pleaded, Mr. Alexander has violated the court's order. I'm not asserting that that little amount of parenting time is necessarily best, or that he should have less parenting time. Maybe just a different schedule would be better for the kids so that they could do other activities and not bounce back and forth. But I would like to at least get the income into the front of the court and get the process started.
Okay, but do we need to start a formal referral, or can that be discussed at mediation? Can they discuss parenting time and child support with Mr. Walker?
We can, but I would like the parties to have to submit their W-2s and their tax returns and their pay stubs. I have no idea what kind of money Mr. Alexander makes. There's never been support ordered.
Ms. Patrick, can order them to produce that when they mediate with Mr. Walker? I'm just trying to be efficient with the front of the court's resources.
We can, Your Honor, or they can be emailed to Mr. Walker the date of the mediation. But I also believe that you had stated in that roundtable meeting that attorneys could use that checklist and send us the information before mediation.
But this proposed order makes the official referral. Do we want to actually refer it for the child support, the formal investigation recommendation?
I asked both attorneys that, Your Honor, because I am in agreement with the court, but Ms. Worski, it's her request. I believe it's in her motion. She requested that the process begin before mediation.
Judge, if we can accomplish, I certainly can run the child support formula, and I'm sure Sister Counsel can too. If you would prefer to order that the parties exchange their W-2s within 7 days, that's fine.
Okay, that would seem to make more sense. You can address that with Mr. Walker. If thereafter is an issue, we can then do the formal investigation recommendation. Ms. Spencer, any objection to the court in lieu of a formal referral, just ordering the parties to within 7 days from today's date to exchange their W-2s?
No, I agree. I think that's more efficient.
Okay. What else do we need? Do we have, some people have not filed tax returns, obviously. They will not have filed them by that March date. What do we need other than the W-2s?
We could do like the most recent pay stubs.
Great.
Okay. Most recent pay stub and W-2. So Ms. Patrick, we can revise this to eliminate the actual referral in front of the court.
Yes, sure.
Unfortunately, this court will not be in the jurisdiction on March 21st. Obviously, the court likes to be available when parties are mediating. I don't know if you wanted to probably be available. Can we do anything before March 21st? Maybe the week of March 11th? Is it Mr. Walker's schedule that's...
Unfortunately, Your Honor, it is Mr. Walker's schedule. He is booked that week. He has no openings that week. The week of the 18th was the first time he had openings.
Okay. What about the first week of April, the week of April 1st? Is he available at all then?
He is available April 1st at 1:30 and April 3rd at 1:30.
Are you available on April 1st?
I sure can be.
We can do April 1st. I'm sorry, Ms. Patrick, was that at 1:30?
Yes.
Nick, are you available then?
Yep.
Okay.
All right. Okay, Ms. Patrick, we can put that Mr. Walker's schedule for April 1st at 1:30, and then the parties can appear before the court thereafter to review the parenting time. Of course, recollection, this court didn't like that bouncing back and forth schedule back in 2018, but the parties agreed to it. So the court was not going to stand in the way of something the parents agreed to. But yes, it seemed like a lot of bouncing back and forth. Of course, the parties last meeting with Ms. LaPrade, and that seemed to be successful. But obviously, Mr. Walker is very capable as well. So, all right, the parties will meet with Mr. Walker then April 1st, 1:30 p.m. It's also going to appear before the court for review. And do you need more than 7 days to exchange the W-2s and last pay stub?
No, we don't.
Okay.
No, I don't believe that should be a problem. I'm sure Mr. Alexander can get them fairly quickly.
All right. So, Ms. Patrick, do you mind to put in the revised recommendation that the parties shall exchange 2023 W-2s as well as the most recent pay stub within 7 days.
Yes, Your Honor.
So the council has that well in advance of the mediation.
I'll be communicating with Mr. Alexander directly going forward because Ms. Spencer's limited appearance will have come to an end. So I will get Mr. Alexander's email from my client so that I can send him her information and he can send me his.
Is that agreeable, Ms. Spencer?
Yes, and I can also provide Ms. Zagorski with his email if that is necessary as well.
Thank you.
Okay. So, Mr. Alexander, you understand, Ms. Spencer, her representation is limited and expires after today. So from now on, you need to deal directly with Ms. Zagorski.
Yeah, yes, I understand that.
Okay. So get your W-2 and your most recent pay stub and email those to Ms. Zagorski. And make a note, April 1st, 1:30. And the reality is, Ms. Lavoy, Kosar, and Mr. Alexander, you know what's best for your respective schedule and that of the two children. And obviously it's worked the last 6 years. So if it needs to be massaged and modified a little bit, do so in what's in the best interest of the children. The children are getting to school on time right now, correct, Mr. Alexander?
Correct.
They moved to Petersburg and it's early. I don't know if Bridget's been complaining, but yeah, most 15-year-olds don't like to be up at 6 o'clock in the morning to be to school at 7:30. I'm not sure what that time frame is, but obviously you should know what's best for your children, better than this quarter than Mr. Walker. So hopefully the two of you can communicate meaningfully in the interim. Right. Anything further this afternoon, Ms. Zagorski or Ms. Spencer?
Yes, Your Honor. We have not been able to address the issue of Mr. Alexander's violation of this court's order and his drinking and driving with the children. I know you've reviewed the pleadings and you probably saw the private investigator's report. It is problematic. If we're going to keep this schedule, and we're 7 weeks out from mediation, I am asking that Mr. Alexander submit to SoberLink at his expense, and also that he reimburse my client the $1,300 she spent on the private investigator, and that he be found in contempt.
All right, Ms. Spencer, what's Mr. Alexander's response? The court did read the investigative report. It seems to, unless we want testimony from former Deputy Rosenberger.
Yes. So our position is that Mr. Alexander hasn't had any convictions for alcohol-related offenses or any criminal offenses at all.
I understand. Hold on, Ms. Spencer. The issue was he consuming alcohol and then transporting the children after he consumed alcohol. The order did prohibit him from consuming alcohol, but he was not to drive the car with the children after consuming alcohol. That's the only question. I saw Mr. Simonton's evaluation. There's no question. I don't think Mr. Alexander has a drinking problem, but it does appear from the evidence produced that he violated this court's order that he consumed alcohol, then operated a vehicle with the children in the vehicle. That's the issue.
So on the day in question on that report, it says that he was never actually seen drinking and that his parents were also with him who drove the children after. So yes, Mr. Alexander drank, but he did not transport the children. He transported himself and there was a separate car with the children and the parents.
No. That's not at all what the report says.
No. The report does say that he was not seen drinking at all. And I'm adding to the fact that he was not driving the children. His parents were there with him.
I'm quoting, Nick and the kids left the restaurant and talked with several family members for several minutes before leaving the establishment in Nick's Jeep with him driving.
I'm quoting to you what my client told me, and that was not what happened.
Okay. Well, I guess we'll have a hearing on that then. You can have produced Mr. Alexander's parents, and we'll have Deputy Rosenberger. So what about the requested pending that hearing? What's your position on the SoberLink? Ms. Spencer?
That our position is that it's not necessary. There hasn't been any incidents occurring where SoberLink would be required.
Oh, okay, I understand. But again, the court does not believe it's alcohol property, but there's on the face, he's violated this court's order. All right, we'll reserve that. Ms. Gorsuch, I'm not going to SoberLink at this point in time. But again, Mr. Alexander, I think you should cut your losses and then work out a resolution as a matter. If not, reimbursing Ms. Closar for the expense of that, minimally reimbursing her for the expense of that private investigator, because otherwise there could be significant consequences if the court finds after hearing that you violated this court order, including but not limited to jail. So, Mrs. Gorsuch, we'll reserve the request for the request for contempt.
Thank you.
And so we'll address that on April 1st. And if we don't have some resolution to that issue at that time, we will then schedule that for prompt hearing.
Thank you.
Mr. Alexander. This court's priority says you consume alcohol, you can go home or drink all you want, but you cannot transport the children after consuming alcohol. I want to make sure that's really clear. That order continues. If you're drinking alcohol to dinner with the kids, give it to one beer. It doesn't matter. You have your parents pick up the kids. You call someone else. And there's nothing that prevents you from consuming alcohol at home when you're with the children. You're just not to drive an automobile with your children in your car. So that's what the report seems to indicates, and if necessary, about hearing that. And if in fact court finds responsible, there will be significant consequences, Mr. Alexander. So that issue will be addressed further if necessary on April 1st at 1:30.
Thank you, Judge.
Ms. Patrick, I'm not sure if I'm giving you too much, but hopefully you can address that. The parties will mediate with Mr. Walker April 1st at 24 1:30 p.m. regarding parenting time and child support. Parties shall exchange their W-2s and last pay stub within 7 days, I think I indicated.
Correct.
And plaintiff's requests for contempt finding the part of Mr. Alexander will be addressed if necessary on April 1st at 1:30.
Got it, Your Honor.
And we will not refer the issue of child support at this time to the front of the court for formal investigation recommendation. Anything further, Ms. Spencer or Ms. Skorsky?
No, thank you, Your Honor.
Okay, that will conclude this matter. Thank you, Ms. Patrick.
Thank you.
Thank you for your patience, Mr. Danielski.
Hello.
Thank you for your patience, Mr. Danielski. Ms. Rios?
Yes.
The court is informed that Mr. Port tried to zoom in off his problems, but he appeared in the past. But nevertheless, it's now 10 after 3. We're going to recall the case.
Court recalls bottom of page 3, Carolina Rios versus Nicholas Port.
Once again, this matter is before the court for review of parenting time. Ms. Rios is present with her attorney, John Danielski. Mr. Poor failed to appear. He was contacted by Ms. Rios through app close. Mr. Poor apparently tried to connect up, but failed. It's now 10 minutes after 3. The hearing was set for 2:30. Mr. Poor could have contacted the court by phone, other means. He's failed to do so. So at this time, the court will simply continue the priority of the court.
Your Honor, my client wanted me to mention one thing. She's asking for some attorney fees. She had to hire me. I had to read the file. It was somewhat lengthy.
Court reserve request for attorney fees. The matter was already set for hearing, so you didn't have to file any other petitions. Just more for review. At this time, the court will reserve at this time request for attorney fees, Mr. Danielski.
All right, and then she was saying, she's getting bugged by her boss because she's been over late, but so she was telling me about that, because she's on a break at work, but she's just a little frustrated because she's here on time, not here. So.
Understood. Thank you, Mr. Rose. Court to recognize that and appreciates that. So you can zoom out, and that includes, remember, we have no future date set.
Thank you, Your Honor.
You're welcome.